how do you also temper clients' expectations? Because, people see these billboards and they hear about all these damages and, some people come in and say, well, I should at least get X, Y, and Z. And so how do you manage those expectations for your clients?
Well, really, I tell them just that. Like, you might see billboards on TV or Facebook ads where these attorneys are settling these cases for millions of dollars, and then I tell them, but really, like, the settlements are a lot lower than you think. And I feel like that puts people in the right mindset from the beginning. And I also tell them that they shouldn't formulate any number in their mind for the amount that they want to settle their case for until we submit our demand letter to the insurance company and we get a response from them. And the reason is because we don't know what the defense is going to say. We don't know what the holes in your case are, the problems. And then when I do get a settlement offer, usually before I tell the client the number, I tell them like a little bit about how we value the cases. Like, a lot of it's based on the medical bills. And I tell them, like, at what point would you want to accept it or decline it? And then I tell them the offer. And I feel like that little speech in the beginning helps me with client control and managing their expectations.
I know in my experience, when it's a low settlement, I obviously have to, and I tell the clients, listen, I have to convey every offer that's given to you. I'm not saying this is the offer that you're to accept, but I have to convey it to you. And obviously a client can always decline unless they're just being unreasonable and they have like a number that's just not ascertainable. And there are clients I've fired because the number they wanted just wasn't even feasible, even if we go to trial, and it just, it meant years of litigation. But I also tell clients, hey, the day somebody gave me opposing counsel, give us a counter offer like $500, and client was out like ranting and raving. I'm like, look, this is just them kind of almost like kind of saying, oh, we don't care. Like, they're going to give you the lowest offer, right? And I'm like, that's just the opening offer. It doesn't mean anything. It just means that at least they're talking some numbers. So I think a lot of times clients don't understand that. They'll get so caught up. And I'm not sure in your experience, I know, in the beginning, there's some activity when we file the case, and there could be a long, pause until there's discovery or there's mediation or whatever. And so I'm challenged all the time because they are clients. In fact, I have a client right now, and they want constant updates, and there's not much, and then they want to rehash the case again. I struggle because I'm generally pretty patient, but I sometimes struggle with this because I'm like, I can't keep giving you the same information when there's been no activity, And so in your experience, how do you do you find that challenging, and how do you cope with it?
Well, I feel like when a client asks for an update, sometimes the attorney feels like they have to tell them something. And I've realized that sometimes just telling clients, like, I have no update for you at this time, it makes them think that sometimes there's just nothing to say. And then they stop asking me for updates. And I always think it's important, though, to call the client back or return their email within 24 hours.
Mm-hmm.
And at the same time, just tell them that sometimes it might take more than 24 hours to get back to them, so that they don't have their episodes with thinking you're ignoring them or whatnot.
I know it's tough because, like, sometimes I also have sometimes a challenge explaining to a client like discovery or what I need, and a lot of times I also struggle with the fact that clients sometimes just want to rant and talk, and I have to start setting boundaries. I'm like, hey, I can talk to you for 10 minutes, but I can't rehash the case from the beginning to now because it doesn't serve the client, it doesn't serve my other clients. So that's the challenge I always struggle with. James, in terms of your practice currently, like what's the percentage, or what do you, what kind of cases are you generally dealing with and what percentage, or give me a rough idea, like.
It might be 50% auto accidents, and then the other 50% kind of a combination of premises and product liability cases. And maybe about half my cases are also in litigation, and then half are before litigation. Like we call it pre-litigation.